Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Former Deputy Chief Minister of Delhi and Aam Aadmi Party leader Manish Sisodia today moved a Delhi court seeking interim bail on the ground of campaigning for the upcoming Lok Sabha polls. Sisodia, as you know, is presently in judicial custody in the alleged liquor policy scam case. The counsel appearing for Enforcement Directorate as well as CBI sought some time to file replies in the matter. Accordingly, Special Judge Kaveri Baveja of Rouse Avenue Courts sought response of ED and CBI on the interim bail plea and listed the matter for hearing on 20th April. You already know Sisodia was first arrested by CBI and then by Enforcement Directorate last year. Sisodia and others have been accused of being instrumental in recommending and taking decisions regarding the 2021-2022 excise policy with an intention to extend undue favors to the licensee post-tender. Sisodia was denied bail by the trial court, the Delhi High Court and the Supreme Court in both ED and CBI cases. Regarding the same case, Special Judge Kaveri Baveja of Rouse Avenue Courts has today remanded BRS leader K. Kavitha to CBI custody till 15th April in the alleged liquor policy scam. Kavitha was produced in court following her arrest by the CBI yesterday. As per CBI, Kavitha is one of the key conspirators in the liquor policy case and is concealing facts which are exclusively in her knowledge. The agency thus sought 5 days custody, which was granted today. She was arrested on 15th March by the Enforcement Directorate in the money laundering case related to the excise policy. She was in judicial custody when the CBI arrested her. This was after CBI recently got permission from court to interrogate Kavitha in jail. The Supreme Court has dismissed a review petition filed by the Indian Army against its judgment delivered in September last year. The petitioner in that case, a former Air Force officer, contracted HIV pursuant to a blood transfusion done at a military hospital. The Apex Court had held both the Air Force and the Indian Army liable for medical negligence and had directed them to jointly pay nearly 1.6 crore of compensation. The review petition was filed against this judgment. A bench of Justices Dipankar Datta and P.B. Varale dismissed the review petition and observed that the judgment and the order under review did not suffer from any error warranting its reconsideration. The officer had also filed a contempt petition against the Army and Air Force for not complying with the directions. While adjourning the contempt petition in view of the pendency of the review petition, the court on 5th March had directed the Army to immediately release 18 lakh rupees to the petitioner towards his medical expenses. 2 practicing advocates from Gujarat have approached the Supreme Court in a petition against a direction of the Gujarat High Court to lodge an inquiry against them for an alleged misconduct of forging the Vakalatnama of their client. On 10th April, a serious issue arose before the Gujarat High Court when 2 practicing lawyers were accused of forging the Vakalatnama for their client, Mr. Bharatbhai Dhirubhai Ahir. Vakalatnama, let me tell you, is a document which authorizes a lawyer to represent a client in the court. The case before the High Court involved a petition to release Mr. Ahir's Toyota Innova car, which had been seized under the Gujarat Prohibition Act. During the hearing, a person claiming to be Mr. Ahir appeared before the court and declared that he had never engaged the 2 lawyers, nor had he filed the petition for the release of his car. He explained that his vehicle was stolen in the year 2016, and although he had filed a police complaint but had not hired any lawyers to recover the vehicle. Upon comparing the signatures, the court concluded that the signature on the petition appeared to be forged. As a result, the High Court directed for a formal complaint to be lodged and a thorough investigation to be conducted into the alleged forgery. The 2 lawyers defended themselves by asserting that they acted in good faith and did not intentionally commit any wrongdoing. They argued that the petition came from a trusted source and they believed that they were genuinely representing the client. It was also pointed out that the case had been adjourned multiple times, suggesting that they had no malicious intent. In their petition before the Supreme Court, the lawyers have contended that the Gujarat High Court overlooked the cogent explanation given, and instead of calling for a written affirmed statement from the respondent, the bench actually took the words of the respondent as the gospel truth and initiated an inquiry. They have sought a stay on the order, contending that such a direction impinged upon their reputation, dignity, and the right to continue their profession. The next update is from the actress sexual assault case involving Malayalam actor Dileep. The Kerala High Court today directed the Ernakulam District and Sessions Judge to give the survivor in the case copies of statements of persons examined during the fact-finding inquiry. In 2022, the survivor actress, who was reportedly kidnapped and sexually assaulted in a moving vehicle in 2017, a crime which allegedly was orchestrated by Malayalam cinema actor Dileep, approached the High Court. The victim had claimed that the memory card containing footage of the assault had been confiscated as evidence. It was assessed, copied, and shared without proper authorization. The trial related to this case is currently ongoing at the Ernakulam District and Sessions Court. Last year, the High Court had directed the Ernakulam District and Sessions Judge to conduct a fact-finding inquiry on the allegations. Recently, the survivor approached the court with two applications. The first application to seek copies of statements of persons examined in the fact-finding inquiry, and the second one to set aside the inquiry report dated 8th January this year, submitted by the Ernakulam Sessions and District Judge. She alleged that the fact-finding committee was conducted in secrecy, denying even her an opportunity to participate in it. That after the inquiry was over, she was even denied a copy of the fact-finding report or depositions of witnesses, which shows malafide on the part of the inquiry authority. Justice K. Babu reiterated that it never intended that the fact-finding inquiry be treated as confidential and observed that the survivor was entitled to copies of statements of persons examined. With respect to the second application, the court stated that it will hear on the maintainability of the petition to set aside the inquiry report after the reopening of the court after summer vacations. In an important update, the Karnataka High Court has refused to direct a husband with 75% disability to pay maintenance to his estranged wife. The court also set aside an order of the execution court which, acting on the plea filed by the wife, had issued an arrest warrant or fine levi warrant against the husband. In this case, let me tell you, the husband had preferred a petition seeking annulment of marriage. The allegation of the husband was that the wife had left the matrimonial house on her own volition. The wife filed an application seeking interim maintenance under Section 24 of the Hindu Marriage Act. The concerned court, after hearing the parties, granted the wife interim maintenance of 15,000 rupees per month in terms of its order dated December 2012. The wife then filed a memo of calculation before the concerned court in the year 2013, claiming arrears to be paid by the husband towards the maintenance so awarded. The concerned court rejected the memo. This was challenged before the High Court. During the pendency of this petition, the husband suffered a stroke resulting in 75% disability, due to which he resigned from his work. However, on the ground that the husband has not paid maintenance to recover arrears of maintenance, the wife initiated execution petition seeking execution of the order of maintenance. The concerned court then directed the father of the husband to pay arrears of maintenance. When this order was not adhered to, a fine levi warrant and arrest warrant were issued against the husband. These also came to be challenged in another petition before the High Court. The husband contended that he is unable to pay maintenance given his 75% disability, which does not get him any job. On going through the records, the bench noted that the wife was qualified and earning. The court said that it was highly ununderstandable as to why and how the wife was insisting on payment of maintenance, looking at the admitted disability of the husband. The court disagreed with the wife's claim that the husband's father should provide maintenance, as she had been supporting herself for the past decade. However, it ruled that the husband's father must support the grandchild's needs, especially education. The court rejected the wife's request for increased maintenance. Additionally, it instructed the husband's father to cover any outstanding maintenance until the husband became disabled. The Bombay High Court has directed the state government to provide medical care to a 17-year-old pregnant girl who did not want to file a police complaint against her minor partner and was refused treatment as a result. The division bench of Justice G.S. Kulkarni and Justice Firdosh P. Puniwala was dealing with a writ petition filed by the girl's mother seeking access to medical treatment which was denied to her daughter because the medical facilities demanded a police complaint before administering treatment despite the daughter's refusal to pursue legal action. The daughter asserted that their relationship was consensual. The petition expressed the intention to give the child up for adoption. The court emphasized that denying medical aid based on absence of a complaint contradicted the constitutional right to health care. The government pleader stated that the daughter can receive treatment at the hospital without her identity being disclosed, but sought a formal statement from the petitioner that her daughter did not want to file a police complaint. It was said that this needs to be made in the form of an emergency police report. The court opined that there was no harm in the petitioner presenting an emergency police report and that such report could be handed over to the government pleader who could keep it in a sealed cover. And when the need arises, it could be utilized for appropriate purpose with the prior permission of the court. The Bombay High Court has issued notice to the state government, Brihan Mumbai Municipal Corporation as well as municipal corporations of Thane and Mira Bhayander in a PIL on the ill effects of installation of decorative lights on trees. The PIL filed by an activist highlights the detrimental effects of decorative lights on trees and organisms living on or around the trees during festivities and other occasions. It states that the unregulated practice of draping, fixing or wrapping bright lights and high-tension cables across the trunks and branches of trees is detrimental to the health and growth of the trees. That trees wrapped with fairy lights and floodlights disrupts wildlife and birds. The petition points out that while such decorations are supposed to be temporary, trees in Mumbai's Malabar Hills, Breach Candy, Walkeshwar and Andheri areas have been draped with lights for several months. The petition seeks various measures from the authorities including public awareness campaigns and the prevention of illegal installations of high-tension cables. It also seeks constitution of a committee of environmental experts and civil society members to ensure that wires, lighting, etc. are not illegally installed on trees, particularly during festive seasons. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.